Hello there and welcome once again to another open door show from Property CEO. Look, it's good to have you here with us. My name's Ritchie and as you know, because it says it on the bottom of the screen, I'm not here again, unfortunately, with Mr. Child, but I'm sure he will be back soon. Maybe we let him do one of his own shows. But for now, you're going to have to put up with me. It's great to have you with us. And over the next 30 minutes, as always, we're going to take a deep dive into the world of small scale property development. We're going to be chatting with people out there, the movers and the shakers. And the most important thing is to have a little bit of fun in doing it. So we will try and endeavor to have a bit of fun over the next 30 minutes. Now, on today's show, really pleased to have a great friend of mine. I've known him for some time. And this is an area that I think a lot of you perhaps have never thought about. A lot of you in development already, or people thinking about getting in development. It's about making sure we absolutely nail our contractual arrangements and how we control those contracts with our contractors. Okay, so important that we get that right, because we can do absolutely everything else. We can find the best site out there, we can get the best finance, the best team. If we don't administer this thing properly and control it, everything could fall apart. So it's so important to absolutely nail that part of the procedure. So I'm very pleased today that we have Michael Taylor from Hawthorn Commercial Services. Michael, hello, welcome.
Hi, good afternoon. How is everyone?
I think we're all good. So, Michael, it's great to have you here. You are a specialist in construction law and a real specialist in sorting out risk management and mitigation on contracts. Is that a best description of you?
Yeah, and also mopping up the problems when people fail to take the advice, which regrettably is more often than not. People not wanting to pay for the advice and then pay handsomely to solve the problem when the problem is manifested into a very large problem. So often we've been called commercial sweeper-uppers, but we prefer to advise prior to contract award, prior to getting into a contract, so that the client and the contract administrator can ultimately deliver a successful project.
I like it. I think the important thing there, folks, is sometimes you just got to pay a little bit up front to make sure that you're not paying a bigger amount at the end should it go wrong. And unfortunately, contracts do go wrong. Tell us a bit more about Hawthorn Commercial Services. Michael, what's a bit about your background? What do you do that's different to a normal sort of contract administrator, project manager?
So myself, I started in the world of quantity surveying some 30 years ago. I feel old when I say that now. And I worked for many years as a quantity surveyor and commercial manager for main contractors, subcontractors, consultancy businesses, for the end client, the end employer. So I've worked in all different camps, different foot in each field, if you like. And really, I've always had an interest in construction law and a subject I'm quite knowledgeable on, and because of that, I normally ended up being the person to solve the problem. So a few years ago, I completed a master's in construction law and adjudication.
Wow!
And we either prepare and submit claims predominantly on behalf of contractors and subcontractors when breaches of contract have occurred. And then raising adjudications, which is a statutory form of dispute resolution in construction. So whether your contract has got it in or not, if your contract hasn't got it in, it's got it in by default under the Construction Act. It will imply in the terms. You cannot get out of it unless you're generating power and oil and gas. And the reason they've got an exemption is because of the lobbying. But where we differ from a contract administrator is that we have expert knowledge of the contract and the law relating to how construction operations and construction contracts have to be run, and the legal duties that are on the contractor and on the contract administrator. Because although a contract administrator is employed by ultimately you as the client, when he or she is acting as a certifier, they have to put an independent hat on, and often the line between independence and bias can be blurred. And sometimes that could be because the contract administrator is also the architect,
yes,
which I never recommend a client do, because if the architect misses something out in the design, well, he's going to have to instruct the contractor to do that work and then tell the client, yeah, you've got to pay him for my mistake. And that could include, of course, additional time and prolongation of a project. So we
can't see many architects throwing themselves under the bus, can you?
No, they often don't. And yes, some of the levels of bias that I've seen in the past is quite shocking, and I think some of them forget that it doesn't matter what their appointment says. There is legal rules implied from case law going from many years back in terms of the conduct of how they have to conduct themselves when they're acting as that independent certifier. They're a little bit like the referee in the football match. They've got to be independent when they're making those decisions that affect the contractor.
Interesting. So quite different to a sort of normal project management firm. Obviously, there's very legal bias. Important to get things right at the beginning. I think we talked about there, interesting, and I think, Michael, we have the same view, and no disrespect to any architects that are listening to this, or indeed the ones that I know across this country. Architects aren't very good more often than not of being contract administrators. And I often say, you'd never get your project manager to do the architecture as well, would you? So why would you get your architect to do the project management? So I think I'm always keen horses for courses. So we have a similar opinion there, don't we, Michael?
Yeah. As I said to a client many years ago, who was a bricklayer, if you read contracts, we're in trouble.
Yeah.
If I lay bricks, we're really in trouble. But if you lay the bricks and I read the contracts, then we'll both be okay and we'll both make money out of this. And your contract that you're delivering will run smoother for you.
I think that's the important thing. It's about these things running smoothly. We don't want to be picking up pieces afterwards. And I think something, probably a few of you listening to this, whenever it's tonight, today, whether you're listening to it on YouTube or listening to it on the podcast, on Spotify, on your way to work, who knows? One of the things that Michael said, he acts for a lot of contractors and subcontractors. I would think I would not want, and I don't think you would, Michael on the other side of the fence, pursuing you. So wouldn't it be much better to have Michael at the beginning of your contract advising you to get that right? I'm sure you're not the easier persons to get one over of if you're working for the contractor, are you?
Well, we do try our hardest.
Okay, Michael, I think what we could do today, because I think it'd be very interesting for everyone listening, we understand that you're a different person to a project manager, but let's talk about contract administrators. And one of the problems that many contract administrators are inexperienced. And I don't mean just architects that are doing it. There's no doubt there are some architects who are very good, but there could be conflicts of interest there. But many people, and particularly new developers, inadvertently, because they don't know any different, employ a contract administrator who is inexperienced. Can we just talk about, maybe we could pick, say, 3 top things that inexperienced contract administrators do wrong? What would be your first, Michael?
Failing to administer the contract. I think
that sounds so simple, but I'm guessing this is important.
It sounds blindingly obvious. And I suppose maybe to me, having that in-depth knowledge of the contract, it's just second nature. But I mentioned earlier about adjudication within contracts. I've been asked, well, can they adjudicate? Shouldn't they go to court first? Shouldn't they do? No. A construction contract, any party can adjudicate a dispute at any time. And whether you like it or not, you will be taking part. And if you don't take part, chances are you'll lose. And the decision from the adjudicator would go against you. You'd have to pay a sum of money to the contractor. Even if that sum of money was not the correct sum, adjudicators can make decisions that are wrong. They can say 2 + 2 = 7, and the court will enforce it.
Wow.
Non-negotiable. They will enforce the decision, and then you would have to re-adjudicate after you had paid the money. So that really links into when I said about contract administration and the correct service of notices, and where the contract says a notice should be, how it should be sent, the form it should consist of, making sure that notices are issued in the correct timescale. So the payment regime is very strict within construction. You have to set out within a contract what's called an adequate payment mechanism. Now, I would always recommend clients to use generally the JCT suite of contracts, which has been around for a very long time. I think best part of 1930, I think it was, Ritchie, when they first came to being.
What are you asking me for? I've been around since 1930, Michael. That's a bit harsh.
I thought you might have known. And they're a mature suite that include those bits of legislation. But if you forget to issue a notice within the correct timescale, you've got an opportunity to remedy that. If you miss the boat and don't remedy that, then you will have to pay what the contractor has asked for. If the contractor adds a nought on to his application for payment by mistake, if the notices aren't given to him, he's entitled to be paid it. And he's entitled to suspend work.
Wow. So we could have a contractor put a claim in for I don't know, £5,000. Yeah, if he actually put in 50,000, but we don't follow the correct procedure and we don't dispute that, then he's entitled to that 50,000.
Yeah. So first of all, he would or could suspend works on the project. So for a developer, that is going to be a problematical situation, because first of all, you're going to have to report back to your funder that the contractor has suspended work.
Yes.
Why? Because you failed to issue or have the correct notices issued. And yes, they could go to an adjudication. It's colloquially called smash and grab for a failure to issue notices, and the court would say, yeah, you have to pay the 50,000 if you refuse to comply with the adjudicator's decision, and you would not be able to commence a true value adjudication until you'd paid the 50,000. So although the law says you can, either party can adjudicate at any time, it is caveated that no, you can't until you've paid.
Yeah. So if a contractor, sorry, Michael, if a contractor said, I'm really struggling with a bit of cash flow, I'm going to put a fast one on here because you've got an inexperienced contract administrator, I'm going to get my 50,000, you'd have to pay it, even if you could claim it back later in subsequent valuations. He's had that money up front.
Yeah. And of course, if you were to lose the adjudication, you'd be stuck with the adjudicator's fees. I just completed one recently, and the adjudicator's rate was £400 an hour.
Wow.
That's round about the common rate. And I think his bill was about 20,000 plus that the client's got to pay.
And something I often say to people as well, and I guess this is absolutely paramount, it comes in, is that as a new developer, you've got to understand, because most of our new developers are working, as a lot of existing developers do, with other people's funds, so commercial funding and drawdowns, and you've obviously got the banks, surveyor coming out and signing off. But what I think people have to understand is your contractual arrangement is between you and the contractor. So if you've messed up your timing with the bank's valuation, if the contractor's genuinely due 50,000 that month and the bank hasn't come out in time, you can't say I'm waiting for the bank, because you've got to pay that money, haven't you?
Very much so. That was one of the things that they made illegal back in the late 90s, was what we call pay when paid. Mm. And a construction contract cannot have a pay when paid mechanism in there. So yeah, if a developer was to say to his contractor, I can't, I can't pay you, I won't pay you until the bank has released the funds to me, that's grounds for suspension, be a breach of contract, and then with all the other costs that would go with that. So yes, getting those notices correct and making sure that the contract administrator is aware of the obligation for that, and also the service of the notices when he issues a notice of, let's say, a default or a breach by the contractor. He should generally, the contract will tell you how to issue it, and the JCT, for example, it's either by hand or prepaid post is what it refers to, prepaid post and or special delivery. So it would have to be special delivery to the address stated in the contract. Now that may be different from the registered address.
So this is interesting. So just thinking, and we're almost going into a second point here. We talked about administration of the contract and payments, but you're now talking, Michael, about almost a second thing that we get inexperienced contract administrators do wrong is the actual serving of this notice. It has to be absolutely precise. If it goes to the wrong address, it's not served properly. Is that correct?
Yeah, correct. So I had a client a little while ago where his contract administrator had not reported some issues to him. The project was a few hundred miles away from where the client lived, and he'd not reported to him that the contractor had basically stopped working on the job because he was in financial difficulties. Of course, what the contract administrator should have done straight away is issued a formal notice under the contract, which is basically a pull your socks up, mate. And if you don't pull your socks up within a set period, then the employer, if he or she wanted to, could then remove that contractor from the project, get a new contractor in, and the costs associated with doing that recoverable from that contractor. But those notices have to be sent to as per how the contract prescribes, and if they're just sent by email, which a lot of the time they are, or just normal first or second class post, they're not effectively served. So it's then generally what people do, they follow up under the impression it is correctly served, and then that constitutes a repudiatory breach of contract, which then means that the contractor can treat the contract as ended and sue the employer for damages.
So you could have a situation,
a messy scenario.
Yeah. So you could have a situation where the contractor, and we've always had this in the industry where contractor suddenly has got problems. So he's either got financial problems or he's taken on too much work or whatever, but he's not serving your site. And what we're saying is, so we're the victim, but if as developers, and we need to get our contract administrator to serve the right notices to say, kick up the arse, get on with this, otherwise you're going to be kicked out. If we don't do that, almost the contractors reverse this whole thing around and he can come back at us.
Yeah, if it's not done correctly.
And then claim off of us and walk off. Can he walk off the project and claim off of us?
If the notice wasn't served correctly, and then the pull your socks up notice, let's call it, and then within the 7 or 10 days, the second notice issued saying you failed to pull your socks up, we're kicking you off. The contractor could write back and say we consider you in repudiatory breach. We accept that, and the contract is now ended. And then they'll be entitled to damages at common law
and loss of profit and so on.
Yeah, that would basically constitute their loss of profit and any of the damages that they've incurred. So not a position anyone wants to be in. And I mentioned earlier the JCT suite. Interestingly or oddly, most of the JCT suite follows the same process for that pull your socks up notice, for example. And if the contractor did pull his socks up, but then 6 months later they slip back down again, you wouldn't have to issue the second notice under most of the JCT contracts, but certain ones, the minor works ones, if he pulls his socks up, that notice then expires. So I've then had an employer whose contract administrator, you know where this is going, he's issued the notice.
I can see exactly where it's going.
The socks have been pulled up. So of course that notice is now dead, it's expired. But then 6 months later, the socks have slipped back down. They've just wrote and kicked him off the job. And we went back, accepted the repudiatory breach and took them to adjudication and got got a handsome payout for the contractor.
So basically, so not only were the socks pulled up, went back down, the contractor got the developer's pants down as well.
Yeah, and of course, the ultimate redress for the client in that scenario would be a claim of professional negligence against his contract administrator on their PI insurance.
Yeah.
Which is then a costly exercise to pursue as well. May get a result, may not. I don't really know what happened with that contract administrator and client. I'm sure they were not the best of friends after we had that adjudication success against them.
I think interesting as well, Michael, just as a complete aside, and we'll pick a third thing up in a minute that inexperienced contract administrators do wrong. But I think one of the problems that I see a lot is that you often get people offering those professional services that don't actually have the full professional indemnity insurance to do so, which you think would be bizarre they wouldn't, but their insurance doesn't always let them take on those roles and responsibilities. That's something you definitely have to check, because otherwise you'd have absolutely no redress, would you?
Exactly, yeah. I mean, when we embarked on doing legal service work, the hike in insurance premium for just general PI to include legal services was substantial. But even then, they caveat out, we are not allowed as a business to do work associated with advising on cladding. And obviously that stems from what happened at Grenfell, and the professional indemnity insurance market has closed its ranks. So you need to check what insurance do these guys have? Not just, I've got it, but what for PI for doing what?
Yeah, very.
Yeah, I knew a guy many years ago who had PI as a quantity surveyor. Well, he was a quantity surveyor, but his PI was just as a management consultant. So it didn't cover him doing quantity surveying tasks. But no one ever checked the fine print to see.
It's okay whilst everything's going okay. And it's like contracts, isn't it? I mean, a lot of people don't even bother with contracts, which is okay if it finishes fine, but it's when it goes wrong, you need these things in place. We talked about payments. We talked about serving of notices. Give us a third area that these inexperienced contract administrators really do mess up.
Well, I would say really the third one is they'll advise a form of contract that is maybe not suitable for that project, and or they won't advise the client to look at making amendments to that contract. So as an example, what with the financial climate we're in, a lot of contractors will want an advance payment. They will always want an advance payment, I would say.
They might want it.
They won't always get it. But what if you make the advance payment and the contractor goes bust? Goodbye to your money. You're an unsecured creditor. Join the back of the queue. So there are forms of contract that have the provision in for advance payment bond. So you're taking out, the contractor is in effect paying for it, but it would be built into the contract sum anyway. So you're paying for it as the developer, but you're having an advance payment bond, so that if they did, get their advance payment, go bust, you've got that insurance backed product that you can claim against. So some of the standard form of contracts have those, some don't. Most of the standard forms of contract, I would say, do need some tweaking amendments depending on what your risk appetite is as a developer. So the standard one is that the employer, not the architect, not the contract administrator, the employer has issued to the contractor an information release schedule. Yeah. So that's when you're going to issue the design to him.
Yeah.
All well and good. Well, has the amendment to that, firstly, would be that I generally advise is to flip it, that the contractor has to provide that information release schedule to the employer, and the employer can give that to the design team, his design team. So
we're spinning it round and we're saying the contractor, you tell us when you want stuff, and we will respond to that.
Yeah, because If you don't, if it's the standard form where the employer has to provide it, and it's not provided in accordance with those dates, then the contractor is entitled to time and money as a compensation for that delay. So that's an easy one to change. Some contracts that people use are what we would call design and build. So although we would have, as the client, you would have an architect in the early stage and a design team that put the scheme together, the detailed nuts and bolts of the design, you actually think, I want the builder to do that.
Yeah.
So we can deal with the novation of that team, so they're then employed by the builder. But the standard form of contract says that for the design and build, that they're only completing the design, and they're only liable for the design that they're completing, not the design that you have had done prior. So we amend the contract to include all the design that has been done, regardless of when it was done. And then, of course, by novating the design team where their employment transfers to being by the contractor, you as a developer are in effect washing your hands of certain liability and passing that liability on. So the standard forms of contract are very good, but there are certain nuances where the amendments, where they would probably want amending, because most clients that I've come across have not really got into their consultant appointments a design release program, so that the consultant knows when they've got to release that design, so that if they don't release that design when they're supposed to, they're running the risk of a breach of contract.
Yeah. That point, Michael, about the novation, I've fallen foul of that myself, actually, where we actually had, and I can't remember what consultant it was, but there was a problem that the contractor came up against, that the design did not work, had to be amended for quite a significant amount of additional cost. And of course, we were under this impression, quite wrongly and naively at that time, that, oh, well, it doesn't matter because it's design and build. But actually, the problem was actually manifested itself in the original scheme design. And when we looked at the RIBA workstage flows, it was actually when we were employing the consultants, and hence that problem became ours, not the contractors. So that's exactly what you're talking about there, isn't it? It's that demarcation.
Exactly. Yeah. Yeah. And, these are, unfortunately, a lot of these amendments have come about because somebody has gone through the pain of it costing them a lot of money, and it ended up in the courts, which is why the amendment is done. And thankfully, the JCT it does carry all the bits of legislation that would be implied if it wasn't written in. So, for example, the failing to provide design information would be a prevention event. That's an implied term, but the JCT captures it anyway. You can't prevent the contractor from completing his mission in terms of building your building.
Yeah. Wow, I think that's really important. I think, as you say here, this is all about. It's a lot of people think the JCT, which is what we recommend to all of our students, is a standard form of contract, but it is. But it's got to be amended and adjusted to suit, hasn't it? Absolutely important.
I think definitely, and I think if you look, you've got to look at the risk profile of the job and the risk appetite for both parties, and you've got to look at, well, ultimately, who's best placed to own and manage that risk. Now, me personally, I consider that in terms of the program requirements for design or the design information, that's best with the contractor. He is the expert in construction and the expert in project and program management. And he should be saying to the design team, right, this is the date I need to know this. And an odd one that people always say, why the hell do they need to know what the carpets or the floor finishes are at such an early stage? Well, the reason they need to know, in one room you might have carpet, in the other room you might have vinyl, and there's a floor change level. So when they're ordering the doors, they don't want the doors to be cut down on site. They want them to come delivered so they can just be put straight in. So little things like that, you can understand why they would be asking for that information so early on.
Yeah, very important.
The advice
Michael,
is flip.
I think that's been brilliant today. I think that's great. We talked about, I mean, there are some great contract administrators out there. There's no doubt about that. There are plenty of inexperienced ones. We talked about failing to sort out payments properly and all the consequences around that, the serving of notices and actually amendments and getting contracts right. I think we've really opened people's eyes today, Michael. Thanks for coming on the show to actually tell people, what this additional sort of legal specialism is about and why maybe a little bit of expenditure up front alongside your project manager can do a world of good. What's the best contact details, Michael, if people want to reach out for you?
Really be email, which is michael@hcs-ltd.org.
And is there a phone number for people to contact if it's easier?
Yeah, I'll give them mobiles. Will be the easiest one. It's always in my back pocket. 07896 029 819.
Great stuff. Just one more time on the mobile, in case people are just grabbing pen and paper.
Sure. 07896 029 819.
Michael, look, that's been brilliant. Thank you for coming in today to record this, and hopefully we will see you again soon.
So they will. Thank you for your time.
Wow, how good was that, folks? I mean, that was brilliant, isn't it? It's just opening your eyes to something which is very different. We always here at propertyCEO trying to give you all the component parts of what you need to be a developer. And if you're out there, if you're thinking you wouldn't mind getting into development, you'd like to dip the toe in the water, don't get put off about what we're talking about. It's about getting your ducks in a row and understanding all these things. I've put together, it's about an hour and a half, a bit of free training, just to dip your toe in the water. Write this down, grab a pen and paper, and I'll give you a link for a free hour and a half training if you want to come and join us. propertyceo.co.uk/SFR. So that's /SFR. Indulge yourself on that. It's another hour and a half for me. What's not to like about that? Hopefully you've enjoyed today's show, and we'll see you on the next version of Open Door. Cheers now. Bye-bye.